CEO dropped Severance Bombshell. Legal had other plans. They say the devil is in the details. What they don't tell you is that sometimes the angels are there too, waiting in footnotes and contract clauses that nobody bothered to read until it was too late to change them. I learned that in a boardroom on the 47th floor, where the city stretched below like a map of broken promises and second chances. The windows were floor-to-ceiling glass, the kind that cost extra in Manhattan real estate, but were worth it for the psychological impact. Made you feel untouchable, invincible, like you were floating above the ordinary concerns of ordinary people. Made you forget how far you could fall if someone decided to push you. My name is Jordan Price, and I used to be the general counsel at Titan Industries. Past tense because Marcus Holloway, our CEO, our visionary leader, our carefully cultivated brand of corporate charisma wrapped in Tom Ford suits and TED Talk platitudes about disruption and innovation, decided that legal departments were overhead expenses that could be optimized away like any other cost center that didn't directly generate revenue. The meeting was called for 4 p.m. on a Wednesday in October, late enough in the day that you couldn't storm out and still pretend you were being professional, early enough that you'd have all evening to sit with what they'd done to you. The timing was deliberate, I realized later. Trap you at the end of the workday when you're tired, when resistance feels harder than acceptance, when all you want is to go home and forget that your career just ended in a conference room that smelled like furniture polish and recycled ambition. The leaves outside were turning gold and red, that last beautiful moment before everything dies and winter takes over. Poetic, maybe, or just October in New York, where nature provides metaphors whether you want them or not, where the city dresses up its decay in autumn colors and calls it beautiful. I'd been with Titan for 8 years, hired as senior counsel when the company was still scrappy and growing, when we had 70 employees instead of 700, when Marcus still remembered people's names and said thank you when you worked weekends to close a deal. Promoted to general counsel after 3 years of proving that legal wasn't just about preventing problems. It was about enabling growth, protecting value, building infrastructure that let the company move fast without breaking everything that mattered. 8 years of contracts reviewed at midnight because deals couldn't wait until morning. 8 years of regulatory filings that kept us compliant while competitors paid massive fines and made headlines for all the wrong reasons. 8 years of litigation managed, settled, or won because I knew when to fight and when to negotiate, when to be aggressive and when to be practical. 8 years of being the person who said yes, but carefully, instead of just no, who understood that legal's job was to enable business intelligently, not prevent it reflexively. 8 years of building a legal department that understood the business instead of just protecting it, that partnered with operations instead of constraining them. That was a strategic asset instead of a necessary evil. Or so I'd thought. Apparently Marcus had different ideas about value and necessity, and whether expertise was worth the cost of maintaining it. Marcus sat at the head of the conference table, 51 years old, silver-streaked hair that looked distinguished in the way only expensive haircuts can achieve, the kind that cost $400 at a Tribeca salon and looked effortless despite the engineering required to maintain it. His suit was Tom Ford, definitely. I'd learned to recognize the cut after years of board meetings where clothing was costume and appearance was currency. The kind of suit that whispered money instead of shouting it, that said success without saying trying. He was the kind of man who believed his own press releases, who'd convinced himself that charisma was the same as competence, that vision mattered more than execution, that the big ideas were what made companies valuable while the people who implemented them were just interchangeable resources to be managed and optimized. Next to him sat Rachel Kim, our CFO. 43, sharp as broken glass, the person who actually ran the company while Marcus took credit for it at industry conferences and in Forbes profiles. She had that particular quality that Asian women in corporate America often develop, simultaneously invisible and hypervisible, overlooked and over-scrutinized, expected to be both aggressive enough to compete and agreeable enough not to threaten. She'd navigated it by being better than everyone else at the numbers, by being so competent that even the men who didn't want to listen had to acknowledge she was usually right. I respected Rachel, liked her even, in the limited way you can like anyone in corporate settings where friendship is always secondary to hierarchy, where today's colleague might be tomorrow's competitor for the next promotion. and David Santos, VP of Operations, sitting across from me, looking uncomfortable in a way that meant he knew what was coming and wished he didn't. David was early 50s, had been with Titan for 6 years, had that operational leader quality of being good at making things work without needing credit for making them work. We'd collaborated on dozens of projects, had mutual respect built on years of solving problems together instead of creating them for each other. Jordan, Marcus said, and something about his tone made my pulse accelerate even before he continued. That particular cadence that executives use when they're about to deliver bad news, disguised as strategic necessity. I want to thank you for your years of service to Titan. You've built an excellent legal department. Past. Tense. That's how you know. When they start talking about what you've done instead of what you're doing, when achievement becomes history instead of ongoing contribution, when praise is delivered in the past tense like a eulogy. We're restructuring our legal operations, he continued, sliding a folder across the polished mahogany. The table between us was expensive. Solid wood, custom made, probably cost $20,000. Everything at Titan was expensive, carefully chosen, designed to communicate success to clients and employees and investors. Moving to an external counsel model, partnering with Morrison and Blake for all our legal needs. More flexibility, access to specialized expertise when we need it, significant cost savings over maintaining an internal legal department. External counsel model. The euphemism for firing your entire legal department and hiring a law firm that would charge 3 times as much per hour, but wouldn't show up as headcount or fixed overhead on quarterly earnings reports. Morrison and Blake is a top-tier firm, he continued, warming to his pitch like this was a strategy presentation instead of a termination notice. They have deep expertise across all the areas we need: corporate law, intellectual property, regulatory compliance, litigation. It's the right move for where we are as a company, the smart evolution as we scale. I opened the folder he'd slid across the table. Termination agreement, effective in 2 weeks. Severance package laid out in clean typography on heavy stock paper. They'd spent money on the presentation of my elimination. 4 weeks of pay, 2 months of continued health insurance, standard COBRA documentation, a non-disparagement clause that would prevent me from saying anything negative about Titan or its leadership in any public forum or private communication that might be construed as damaging to the company's reputation. 4 weeks, 8 years reduced to 1 month of salary. Less than half a paycheck for each year I'd worked. Less than I'd be paid if I was an hourly employee who'd merely shown up and done the minimum for 8 years, instead of building something that had actually protected and enabled the company. "This is your severance offer?" I asked, keeping my voice level, even though something cold was spreading through my chest like ice water, even though I could feel anger building behind my professional facade. "It's a generous package," Rachel said, and I caught something in her expression, discomfort maybe, disagreement she wasn't allowed to voice, the look of someone who'd argued against this decision and lost, or who'd been told to make it work regardless of personal opinion. Standard for executive separation packages in the current market. Standard. 4 weeks for 8 years. That was their math, their definition of generous, their idea of what my work was worth. The contracts that had saved them millions in litigation settlements, worth 4 weeks of salary. The regulatory compliance programs that had kept them out of the kind of trouble that destroyed competitors, worth 4 weeks of salary. The deals I'd structured that made the company valuable enough for Marcus to take credit, worth 4 weeks of salary. I thought about the Mercor deal 2 years ago, the acquisition that would have exposed us to massive environmental liability if I hadn't caught the issues buried in 2,000 pages of due diligence documents. Marcus had presented it to the board as his strategic vision, but I'd been the one doing document review at 3 a.m., finding the problems, restructuring the deal to protect us. We'd saved $15 million by not buying contaminated properties that would have required years of remediation, worth 4 weeks of salary. I thought about the patent litigation last year, where a competitor had sued us for infringement, demanding $20 million in damages. I'd managed that case, found prior art that invalidated their patents, negotiated a settlement for $200,000 when they'd been asking for 100 times that amount, worth 4 weeks of salary. I thought about the SEC inquiry 6 months ago, when our financial disclosures had been questioned, when there were whispers about securities fraud and potential criminal referrals. I'd managed that investigation, prepared the responses, demonstrated compliance, closed the inquiry with no findings and no penalties when other companies facing similar questions had paid tens of millions in fines, worth 4 weeks of salary. That was how Marcus Holloway valued expertise, how he measured contribution, how he defined generous. "What about my employment contract?" I asked. Marcus exchanged a glance with Rachel. Quick, uncomfortable, the kind of silent communication that happens between executives who've already discussed this, already planned for this question, already decided how to handle it. "Your employment contract has standard severance provisions," Rachel said carefully, choosing her words with the precision of someone who understood that what you said in termination meetings could become evidence later. 4 weeks is consistent with those provisions. "My employment contract specifies severance equal to 1 month of base salary for every year of service, with a minimum of 6 months for executives terminated without cause," I said. Not asked, stated. Because I'd read my contract carefully when I signed it 8 years ago, and more importantly, I'd read it again last week when I'd heard rumors about restructuring through the network of executive assistants who knew everything before executives pretended to make decisions. That would be 8 months of severance, not 4 weeks. Silence fell over the conference room like snow, sudden and complete. The kind of quiet that fills expensive spaces when someone points out that the emperor isn't wearing clothes, when the comfortable narrative of necessity gets interrupted by the inconvenient reality of what was actually agreed to. "The contract also expired 2 years ago," Marcus said, recovering his composure with the smooth efficiency that had gotten him the CEO position, that made him good at fundraising and terrible at operations. "You've been working under at-will employment since then. Standard California law, either party can terminate the employment relationship at any time for any reason, or no reason at all. 4 weeks is actually generous under at-will employment." "The contract had an automatic renewal clause," I said, pulling out my phone, opening the document I'd saved there last week, when careful reading had seemed like paranoia, but turned out to be preparation. Section 12, subsection C. "This agreement shall automatically renew for successive 3-year terms unless either party provides written notice of intent not to renew at least 60 days prior to expiration." Did Titan provide that notice? Another glance between Marcus and Rachel. This one longer, more uncomfortable, the kind of glance that communicates "oh shit" without words. "I don't recall," Marcus said, which was executive code for yes, but I'm going to pretend uncertainty gives me options. "Because you didn't," I said, setting my phone on the table, the contract visible on the screen, the automatic renewal clause highlighted in yellow from when I'd marked it up last week. I would have noticed formal notification that my employment contract wasn't renewing. HR would have required my signature on acknowledgement. There would have been a paper trail. So, under the automatic renewal clause, which neither party canceled, the contract renewed for another 3-year term 2 years ago, which means I'm currently in the 2nd year of that renewed term, which means all the severance provisions still apply. Marcus leaned back in his chair, and I watched his expression shift from confident to calculating. The look of someone doing math in their head. Math that didn't add up the way he'd expected when he'd walked into this meeting with his insufficient severance offer. "That's an interesting interpretation," he said, which was CEO code for, "I don't like what you're saying, but I can't immediately prove you're wrong. That's what the contract says, word for word. And I'm the one who drafted it 8 years ago, so I'm pretty familiar with the language and the intent behind it." "We'd need to verify that with legal counsel," Rachel said, pulling out her laptop. Already searching for files, already doing the mental calculation of what this would cost if I was right, what it would cost to fight if I was wrong. "I am legal counsel," I said. "The general counsel, actually, the person you're presumably counting on to not read the fine print carefully before accepting whatever you decided to offer." "Even so," Marcus said, "we should review the actual contract language before making any commitments about severance." "Feel free," I said, forwarding the document to Rachel from my phone, watching her email notification ping on her laptop. "I've just sent you the original executed contract with both signatures, mine and yours, Marcus, from 8 years ago when you personally approved these terms." Rachel opened the attachment, started reading. I watched her expression shift as she found the automatic renewal clause, as she realized I was right, as she started calculating what 8 months of my salary would cost compared to the 4 weeks they'd been planning to pay. And while you're reading, I continued, because once you start pushing back, you might as well push hard enough to actually move things. You might want to review Section 8, subsection A, which specifies that severance includes continuation of all benefits during the severance period, including but not limited to health insurance, life insurance, disability coverage, 401k matching contributions, and equity vesting schedules. So it's not just 8 months of salary, it's 8 months of full compensation and benefits. Even if the contract is technically still in effect, Marcus said, and the word technically told me he was already looking for ways around it, already thinking about how to spin this as unreasonable demands instead of contractually obligated payments. 4 weeks is what we're prepared to offer. You're free to consult with an attorney if you disagree. We can have our legal team review it. I am your legal team, I said again, letting that sink in, letting them sit with the irony that they were threatening to have lawyers review a contract that I'd written, that I'd negotiated, that I'd ensured had appropriate protections precisely because I understood that employment was always temporary and contracts were shields against future betrayals like this one. Or I was until about 10 minutes ago when you decided legal expertise was overhead to be optimized away. What are you suggesting? Rachel asked, and there was something in her voice, not hostility, but curiosity. Professional interest. The tone of someone who respected competence even when it was inconvenient, who wanted to see how this played out because she understood that this was about more than money. It was about whether contracts meant what they said or just what was convenient for the party with more power. I'm suggesting that Titan Industries owes me 8 months of severance under the terms of my employment contract, I said, plus continuation of all benefits during that period, including health insurance, 401k matching, and equity vesting, plus the accrued vacation time that Section 9 specifies must be paid out at termination. That's another 3 weeks of salary that wasn't mentioned in your generous offer. I paused, let that register, then continued. And if you want to contest any of that, we can have that conversation in court, where discovery will be very interesting, where I'll have the opportunity to review all board communications about this restructuring, all emails discussing the decision to eliminate the legal department, all financial analyses that were used to justify this move, where I'll be able to ask under oath whether this decision was really about efficiency and specialized expertise, or whether it was about making the numbers look better before the acquisition discussions that I know are happening, because I reviewed the preliminary term sheets last month. The temperature in the room dropped 10 degrees. Marcus's expression hardened from corporate smooth to genuinely angry, the mask slipping for just a moment to show what was underneath. A man who didn't like being challenged, who was used to people accepting what he offered, because fighting back was harder than moving on. "Is that a threat?" he asked, voice cold. "It's a description of what happens when you try to shortchange your general counsel on contractually obligated severance while she's still technically employed and has access to every contract, every email, every document that might be relevant to wrongful termination claims or securities violations or any of the other interesting legal issues that companies face when they don't honor their obligations." David Santos shifted in his chair, finally speaking for the first time. "Maybe we should take a moment to review the actual contract language before we continue this conversation. Make sure we're all working from the same understanding of what the document actually says." Smart man. That's why he'd survived in operations. He knew when to slow down, when to check assumptions, when to avoid making expensive mistakes by acting on incomplete information or wishful thinking about what contracts did and didn't require. "Good idea," Rachel said, and I could see her doing the cost-benefit analysis in real time, calculating the expense of paying what was owed versus the cost of litigation, discovery, potential securities issues if acquisition discussions were exposed prematurely. "Let's table this discussion until we can review the documentation carefully. Reconvene tomorrow morning, 9 a.m. Marcus didn't look happy, but he nodded. Pride and anger were expensive luxuries when you were facing someone who actually knew what they were talking about, who'd written the contract you were trying to ignore, who had leverage and knew how to use it. "Fine," he said. "We'll reconvene tomorrow morning. But, Jordan, I'd suggest you think carefully about how you want to handle this. Burning bridges on your way out isn't good for anyone's career. I'm not burning bridges, I said, standing, gathering the folder with their insufficient severance offer. I'm enforcing the contract that you signed 8 years ago, that you personally approved, that you told me was reasonable protection for an executive position. If that feels like bridge burning to you, maybe that says more about your expectations than my behavior. I walked out of that boardroom into afternoon light that felt different than it had an hour before. Not worse exactly. Clearer. Like someone had cleaned windows I didn't know were dirty. Like I could see things I'd been deliberately not looking at for years. The way Marcus took credit for other people's work. The way legal was always fighting for budget and recognition. The way expertise was respected right up until it became expensive. My office was on the 45th floor, 2 floors below the executive suite. Corner office, which was supposed to be a status symbol, but mostly meant I had windows on 2 sides and could watch the city from different angles. The view faced south toward the financial district and the harbor beyond, the Statue of Liberty just visible on clear days. A reminder that symbols of freedom looked better from a distance. I closed my door, sat at my desk, pulled up the employment contract on my computer, read through it carefully, even though I'd practically memorized it over the past week. The severance clause was crystal clear, written in language that left no room for creative interpretation. In the event of termination without cause, employee shall receive severance payment equal to 1 month of base salary for each year of continuous service, with a minimum of 6 months for executive positions, plus continuation of all benefits during the severance period, including health insurance, life insurance, disability coverage, 401k matching contributions, and equity vesting schedules, 1 month per year, 8 years of service, 8 months of salary, at my current compensation of $240,000 annually. That was $160,000 in severance pay, plus benefits, which added another 30% in health insurance, 401k matching, and equity vesting. Over $200,000 total that they owed me and had tried to reduce to the cost of 4 weeks. About $18,000. They'd tried to shortchange me by nearly $200,000, hoping I wouldn't read carefully, wouldn't push back, wouldn't enforce what was actually agreed to. The automatic renewal clause was equally clear. This agreement shall automatically renew for successive 3-year terms, unless either party provides written notice of intent not to renew at least 60 days prior to expiration. Notice must be provided in writing via certified mail or hand delivery with signed acknowledgement. I search my email archives going back 3 years. Search for keywords: renewal, expiration, intent not to renew, contract termination. Found nothing. Checked my physical files, the organized folders where I kept every important document from my employment. No notice of non-renewal, no certified mail receipts, no signed acknowledgments, because they hadn't sent one. Because either they'd forgotten the automatic renewal clause existed, or they'd deliberately ignored it, hoping I wouldn't notice, hoping I'd just accept their at-will employment claim without checking. I pulled up the email from 8 years ago, where Marcus had approved the contract, found it buried in old files, the subject line simple: employment agreement, Jordan Price. His response had been brief, typed on his phone during some meeting or flight. Severance terms are reasonable for an executive position. Automatic renewal makes sense. We want to retain good people. Approved. Welcome to Titan. Reasonable. Automatic renewal makes sense. His words, his approval, his agreement that protecting executives from exactly this kind of casual elimination was worth putting in writing. Now he was trying to ignore what he'd agreed to, hoping that I'd forgotten or wouldn't fight back, or would just accept whatever he offered, because fighting was harder than moving on. I made copies of everything, printed them on the office printer, watching the pages stack up with evidence of what was owed and what had been offered, saved digital copies to 3 separate cloud storage accounts, one personal, one that was technically questionable but practically necessary, one using a service based in Ireland because data jurisdiction mattered for information you might need to protect, emailed copies to my personal address with innocuous subject lines that wouldn't trigger any IT monitoring. Then I did something I'd never done before in 8 years of employment. Something that made me uncomfortable but seemed necessary given what had just happened in that boardroom. I started going through corporate files looking for information that might be relevant to why they were really eliminating the legal department, not client files. I wasn't going to violate attorney-client privilege, not privileged communications about ongoing matters, corporate records, board minutes, strategic planning documents, financial analyses, the kind of things that general counsels have access to because someone needs to know where the bodies are buried, where the risks are hiding, where the problems might emerge. What I found was interesting, very interesting. Board minutes from August showed that Marcus had proposed the legal department restructuring as part of broader cost-cutting measures. 2 board members, Sarah Chen and Robert Morrison, had questioned the decision, asked about the costs of transition, the risks of losing institutional knowledge, the potential expenses if Morrison and Blake turned out to be more expensive than advertised. Marcus had assured them that the transition would be smooth, that severance costs would be minimal and manageable, that Morrison and Blake's quoted rates were lower than maintaining an internal department. He'd specifically mentioned that most of the legal team were at-will employees who could be let go with standard 2-week severance, that only I had any kind of employment agreement, and that agreement had expired, so I'd be at-will as well. He'd lied to the board, or more charitably, he'd been operating on bad information, had never bothered to check whether my contract had actually expired or whether the automatic renewal clause had been triggered. Either way, he'd made representations to the board about the financial impact of this restructuring that were materially inaccurate. He'd told them severance costs would be minimal, when in reality, I alone was owed over $200,000. He'd told them I was an at-will employee when I was actually protected by a contract he'd personally approved. And those misrepresentations had influenced the board's vote on the restructuring. They'd approved it based in part on the cost projections Marcus had provided, projections that were wrong by a significant margin. That was the kind of thing the SEC cared about. Material misrepresentations about financial obligations, executive decision-making based on inaccurate information, board governance failures where directors weren't provided accurate data to make informed decisions. I kept reading, found the preliminary term sheets for acquisition discussions. Titan was being shopped to 2 potential buyers, one a strategic acquirer who wanted our technology, one a private equity firm that wanted to roll us into a portfolio company. The acquisition discussions were sensitive, pre-LOI stage, the kind of thing that could move the stock price if it leaked. Marcus's restructuring plan wasn't about efficiency or specialized expertise. It was about making the EBITDA numbers look better before acquisition due diligence. Cutting fixed costs, my salary, my team's salaries, and replacing them with variable costs that could be managed down. Making the profit margins look healthier for potential buyers who would pay more for a company that appeared more efficient. The kind of financial engineering that made executives look good in the short term while potentially making the company weaker in the long term. But Marcus wouldn't care about the long term. He'd get an acquisition bonus, a golden parachute, a pat on the back for delivering shareholder value. The fact that he'd eliminated institutional knowledge and created dependency on expensive outside counsel wouldn't be his problem once the deal closed. I spent 3 hours going through files, documenting what I found, understanding the full picture of what was really happening. By the time I left the office at 8 p.m., I knew exactly what leverage I had and exactly how to use it. My phone rang at 9:30 that night. I was home, still in my work clothes, drinking wine that was too expensive for a Wednesday night, but seemed appropriate given the circumstances. Rachel Kim's name appeared on my screen. "Jordan," she said when I answered, "I've been reviewing your employment contract. And, you're right, the automatic renewal clause is clear, and we have no record of providing notice of non-renewal. The contract is still in effect. You're entitled to 8 months of severance plus benefits." Continuation. "So we agree on the facts." "Yes." She paused, and I heard something in the silence. Calculation, consideration, the sound of someone deciding how much to say. "I want to make you an offer." "I'm listening." "Marcus is..." She paused again, choosing words carefully even on a call that wasn't being recorded, that wouldn't become part of any official record. "He's difficult. He doesn't like being told he's wrong, doesn't like being challenged, especially publicly. If we go back into that meeting tomorrow morning, and you push this issue in front of him and David, he'll fight it. Maybe unsuccessfully, but he'll drag it out, make it expensive, contest every detail out of pride. He'll make it personal in a way that won't benefit anyone. And you're calling to suggest what, exactly? I'm authorized to offer you a settlement. The 8 months you're contractually entitled to, plus an additional 4 months on top of that. 1 full year of severance, plus full benefits continuation, accelerated equity vesting, payment of all accrued vacation time, and a mutual non-disparagement agreement. In exchange, you sign the separation agreement tomorrow morning, and we handle this quietly without litigation or board involvement or any of the complications that could arise from contested severance. 12 months instead of 8. An additional 4 months of salary, $80,000 more than what I was owed. Over $280,000 total, plus benefits that brought it closer to $360,000. Why, I asked, though I already understood what she was really buying. Because Marcus made promises to the board about restructuring costs that your actual severance complicates. Because the numbers he gave them about savings from outsourcing legal don't work if we have to pay you what you're actually owed. Because Morrison and Blake is already getting nervous about the transition. Apparently you mentioned something to their team about complexity of knowledge transfer, and they're starting to add contingencies to their engagement estimate. I may have been honest with them about what they're taking on, I said. I'm sure you were. Her voice had the dry humor of someone who appreciated competence even when it was inconvenient. And because the acquisition discussions are at a sensitive stage, and the potential buyers are already deep into financial due diligence, if they find discrepancies between what Marcus represented to the board and what the actual obligations are, that raises questions about governance and financial controls and whether other representations are similarly optimistic. So, you're paying me to be quiet about the board misrepresentations. I'm paying you what you're owed, plus a premium for avoiding expensive litigation, potential regulatory complications, and the kind of board drama that could derail acquisition discussions when they're 90 days from term sheet to LOI. Am I being clear enough? She was. Crystal clear. She was buying my silence about Marcus's material misrepresentations to the board, about the financial engineering disguised as strategic restructuring, about the SEC issues that could emerge if someone started asking uncomfortable questions about board governance and executive decision-making based on inaccurate information. Not because any of it was necessarily criminal, probably just negligence or wishful thinking rather than intentional fraud, but because it was complicated and messy and exactly the kind of thing that made acquisition due diligence teams nervous, made board members question management competence, made regulatory agencies curious about whether other disclosures were similarly unreliable. I want 6 months on top of the 8 I'm owed, I said, because negotiation was a habit and the leverage was real. 14 months total, and I want the severance paid as salary continuation rather than lump sum, so it doesn't create immediate tax burden, spreads it across fiscal years. And I want the equity vesting fully accelerated, not just continued through the severance period. And I want a reference letter from you, not Marcus, because he's not going to write anything useful. Silence on the line, long enough that I wondered if I'd pushed too hard, asked for too much, overplayed the leverage that came from knowing what I knew and being willing to make it complicated if they made it necessary. Done, she said finally. 14 months of salary continuation, full equity acceleration, all unvested shares become immediately vested upon separation. I'll write the reference letter personally. It'll be detailed and positive because you've earned that and because I don't want you going to a competitor and bad-mouthing us out of spite. I don't do spite, I said. I do contracts. I noticed. Something in her voice shifted, became more personal, less CFO and more human. For what it's worth, Jordan, I argued against this restructuring, told Marcus that legal wasn't just overhead, that you'd saved us more than your salary cost, dozens of times over, that institutional knowledge mattered. He didn't want to hear it. The board didn't want to hear it. Everyone was focused on the acquisition prep and making the numbers look right. I appreciate you saying that. Do you? Or are you just being professional? I thought about that. About whether I cared about her acknowledgement, whether it mattered that she'd recognized my value even if she hadn't been able to protect my position, about whether validation from someone who'd failed to prevent my elimination was worth anything. I appreciate it, I said, and meant it. Not because I need validation. I know what I contributed, but because it suggests you understand what they're losing, what Morrison and Blake will struggle to replace. That matters, even if it didn't change the outcome. They'll figure it out, Rachel said. Probably. When something goes sideways and they get a six-figure bill from Morrison and Blake to fix a problem you would have prevented for free as part of your salary. That's their learning curve to manage. Indeed, I'll have the revised separation agreement ready by 9 a.m. It'll show 8 months. That's what goes in the official record, what the board sees. The additional 6 months will be structured as consulting fees for knowledge transfer and transition support. Different budget line. Doesn't show up as severance expense. Makes Marcus's numbers to the board work out properly. Consulting fees for services not rendered. Consulting fees for your agreement not to render services that would complicate our acquisition process. Her voice was dry. The distinction matters for accounting purposes. We said goodbye, and I sat in my apartment with my wine and my view of the city, thinking about leverage and negotiation and the difference between what you're owed and what you can get if you understand the full situation. 8 months had become 14. Contractual obligation had become negotiated premium. What should have been a fight had become a transaction, clean and profitable for everyone involved. Marcus would think I got what I was owed, nothing more. The board would see numbers that matched what they'd been told. The acquisition would proceed without uncomfortable questions about governance and financial controls. Rachel would have managed a problem efficiently, and I would walk away with over $400,000 in total compensation for the inconvenience of being eliminated from a job I'd been good at. The agreement arrived in my inbox at 8:15 the next morning. I reviewed it carefully over coffee, noting how they'd structured the additional 6 months as consulting fees, how the equity acceleration was worded, how the mutual non-disparagement clause was carefully crafted to prevent me from discussing the separation terms while allowing me to describe my work and accomplishments. Professional work. The kind of clean contract drafting that made me appreciate Rachel's competence even as I was being paid to leave. The meeting at 9 a.m. was brief. Same boardroom, same people, different energy. Marcus sat at the head of the table, looking like someone who'd spent the night being told he was wrong and didn't enjoy the experience. "We've reviewed your employment contract," Rachel said, speaking for the group, managing the message. "The automatic renewal clause is valid and enforceable. We have no record of providing timely notice of non-renewal. Therefore, the severance provisions apply as written. You're entitled to 8 months of severance plus benefits continuation, as specified in Section 8 of the agreement." Marcus said nothing, just stared at me with the kind of expression that executives wear when they've been outmaneuvered by someone they'd underestimated, when they've learned that expertise includes knowing how to protect yourself from people who view you as expendable. "I've prepared a revised separation agreement reflecting the contractual terms," Rachel continued, sliding a folder across the table. "Different folder than yesterday, better paper, more pages because lawyers get paid by complexity. This supersedes the previous offer. We'd like this resolved by end of day Friday if possible." I opened the folder. The agreement showed 8 months of severance, paid as salary continuation over the 14-month period because reasons. Benefits continuation through the full term. Equity acceleration, vacation payout. Mutual non-disparagement. Reference letter attached as Exhibit A, already written and signed by Rachel, describing my work in terms that would make any future employer interested. "This looks acceptable," I said, because it did, because they'd drafted it properly and included everything we'd discussed. "My attorney will review it today, but assuming everything matches our discussion, I can have it executed by tomorrow morning." "Excellent," Rachel said. "We appreciate your professionalism in resolving this matter efficiently." Professionalism. The word they use when you've beaten them, but let them save face. When you've taken what you're owed plus a premium, but haven't rubbed their noses in it. Marcus finally spoke. "I'm sure you understand this is just business, nothing personal." "Of course," I said, standing, gathering the folder with the agreement that actually reflected what I was worth. Just like my review of the employment contract was just business. Just like my enforcement of the terms you personally approved 8 years ago was just business. Nothing personal at all. I walked out of that boardroom for the last time, and the city below looked different than it had 24 hours earlier. Same buildings, same streets, same bridges. But I was seeing it from a different perspective now, Not as an employee worried about job security, but as someone who'd successfully navigated a termination by understanding contracts better than the people trying to minimize their obligations. My office felt strange for the next 2 weeks. I was still technically employed, still showing up, still available for questions about transition and knowledge transfer that mostly didn't come because Marcus was avoiding me, and Morrison and Blake's team hadn't really started yet. David Santos stopped by one afternoon, closed the door, sat down in the chair across from my desk without asking. "That was impressive," he said. "What you did in that meeting." I just read my contract carefully. Most people don't. Most people trust that HR has their best interests in mind, that the company will do the right thing, that contracts are just formalities. You knew better. I'm a lawyer. Reading contracts is literally my job. He smiled, and it reached his eyes. Marcus is furious, you know. Feels like you extracted money you didn't deserve. Took advantage of a technicality to inflate your severance. The contract isn't a technicality. It's what we agreed to, what he personally approved. I know, and for what it's worth, I think you handled it perfectly. He was trying to shortchange you, trying to eliminate legal expertise while pretending it was about efficiency and strategic evolution. You called him on it. That takes courage. It takes a good contract and detailed records. It takes knowing your value and being willing to enforce it. He stood to leave, then paused at the door. Morrison and Blake is going to struggle without you. You know that, right? You weren't just processing legal paperwork. You understood the business, understood what we were trying to do, structured deals that enabled growth instead of just preventing liability. That's rare. Marcus will figure that out eventually, probably when something goes wrong and the external counsel bills $200,000 to fix a problem you would have prevented. That's his learning curve to manage, not mine. True. He shook my hand. Good luck with whatever you do next. And if you ever want to talk about opportunities, I know people. People who actually value legal expertise. My last day was a Friday in late October. 2 weeks after the termination meeting, the leaves outside now mostly fallen. Winter starting to assert itself in that way New York winters do. Slowly at first, then all at once. No ceremony, no goodbye lunch, no company-wide email acknowledging my departure. Just a brief message from Rachel, thanking me for my years of service and wishing me well. Marcus didn't email, didn't call, didn't acknowledge my departure at all beyond the separation agreement we'd both signed, which told me everything about how he viewed employees who had the audacity to enforce their contracts instead of accepting whatever was offered. I left at 3 p.m., walking out with a box containing a coffee mug, a plant, a few personal items that had accumulated over 8 years. The security guard in the lobby was someone I'd helped once. His son had been arrested, needed legal advice, and I'd spent an evening helping him understand the charges and his options. He saw me leaving with the box, and his expression shifted to concern. "Moving on?" he asked. Something like that. "Sorry to hear it. You were always good people." He lowered his voice. "And between you and me, this place needs people like you, people who actually know what they're doing instead of just talking about vision and strategy." "Thanks. That means more than you know." I walked out into October afternoon, into air that smelled like cold concrete and fallen leaves, into the kind of autumn day that makes you think about endings and beginnings and whether they're really all that different. The city looked different from street level than it had from the 47th floor. Louder, messier, more human, more real. The severance payment started the following week. Direct deposit every 2 weeks, exactly as if I was still employed. My salary continuing as if nothing had changed, except I didn't have to show up or do the work, or pretend that corporate culture was anything other than elaborate theater. For the next 14 months, I would be paid over $400,000 to do exactly nothing for Titan Industries. I spent November decompressing, sleeping late without guilt, reading books I'd bought years ago and never had time for, taking long walks through the city without checking my phone compulsively, without answering emails during dinner, without feeling like I was behind on something urgent that couldn't wait until morning. December. I started networking, let people in my professional network know I was available for consulting or a new general counsel position. The responses were immediate and interesting. Apparently, my reputation had preceded me in ways I hadn't realized, while I was busy being invisible but effective at Titan. 3 former colleagues reached out within days, all of them having left Titan over the past 2 years for greener pastures, or at least pastures where the grass wasn't actively dying from lack of attention. All of them had opportunities they thought I might be interested in. Michael Chen had started a fintech company and needed someone who understood regulatory compliance in the financial services space, who could navigate SEC requirements and state banking regulations, and the complex maze of rules that made fintech either transformative or illegal, depending on how carefully you structured things. Sarah Morrison had joined a private equity firm that needed legal expertise for portfolio companies, fractional general counsel services for mid-sized businesses that couldn't afford full-time executives but needed sophisticated legal support. David Patel was building a consulting practice specifically for companies in that awkward middle ground, too big for their founders to handle legal themselves, too small to justify hiring a full legal department. The kind of companies that needed what Titan had just eliminated. I took meetings with all 3, listened to their pitches, their visions, their promises that working with them would be different from working for Marcus Holloway. Thought about what I wanted next, another executive role where I'd be at risk of elimination when the next restructuring came around, or something different, something that gave me more control over my career and my future, and whether I got paid what I was worth. I chose Sarah's opportunity, partnership equity in a consulting practice that provided fractional general counsel services to private equity portfolio companies, control over which clients I worked with, which matters I took on, how I structured my time, ownership stake that meant I was building equity instead of just drawing salary, that meant I had protection against being optimized away because I'd be part of the ownership structure instead of just an employee. The irony wasn't lost on me. I was building a business model that specifically served companies that needed legal expertise but couldn't afford or didn't want to maintain full-time legal departments. Companies exactly like Titan, which had just eliminated its legal department in favor of the Morrison and Blake model that I knew from industry contacts was already struggling. February brought a call from David Santos. "Morrison and Blake isn't working out," he said, without preamble, without small talk, with the directness of someone who'd learned that lawyers appreciated efficiency. "What happened? They're competent, but they don't know our business, don't understand our risk tolerance, our growth strategy, our culture. Every question requires research at $400 an hour. Every decision requires consultation with senior partners who bill at $700 an hour. We spent more on legal fees in Q4 with them than we spent on your entire department's annual budget." "I'm sorry to hear that." "Are you?" His tone was dry. "Because you predicted this would happen. Told them during transition that institutional knowledge was hard to transfer, that understanding the business mattered as much as understanding the law. I may have mentioned that. We want to bring you back, different structure this time, consulting arrangement, fractional general counsel model, whatever you want to call it. You'd provide strategic oversight, handle the complex matters, manage outside counsel when needed. 20 hours a week, better hourly rate than we were paying you before when you calculate total comp." I thought about it. Thought about Marcus and his elimination and his betrayal. Thought about whether I wanted to work with Titan again even on better terms, even with more control, even with the satisfaction of being brought back after they had learned the hard way what losing institutional knowledge actually cost. "Marcus still CEO?" I asked. "No. Board pushed him out in January. Acquisition fell apart during due diligence. Buyers found irregularities in financial representations to the board. Questions about governance and whether other disclosures were similarly unreliable. Marcus resigned rather than be terminated. The acquisition fell apart. The irregularities I'd known about. The misrepresentations I'd documented. The discrepancies between what Marcus told the board and what the actual obligations were. The same issues Rachel had paid me premium severance to stay quiet about. But due diligence professionals were good at their jobs and found the problems anyway. Who's CEO now? External candidate, former CFO from a competitor, actually understands operations and financial controls. First thing she did was review the Morrison and Blake relationship and start asking why we were spending 3 times what internal legal cost us for worse results. What about Rachel? Still here, promoted to Chief Operating Officer. She's the one who suggested we reach out to you. I thought about Rachel, about how she'd handled my severance, about how she'd recognized value even when it was inconvenient, about whether working with her in a structure I controlled would be different from working under Marcus's charismatic incompetence. "I'm not interested in returning as an employee," I said, "but my consulting practice does offer fractional general counsel services, strategic oversight, complex matters, outside counsel management. We could discuss an engagement." "How much?" I named a rate. It was more than they'd paid me annually when you calculated hourly against full-time, but significantly less than Morrison and Blake was charging, and with better results, because I actually understood their business, their risks, their culture, their history. "When can you start?" The engagement began in March. 20 hours a week, structured as consulting services from my practice, paid at rates that made my previous salary look quaint. I reviewed major contracts, advised on compliance matters, attended board meetings when legal issues were on the agenda, managed outside counsel when specialized expertise was needed. It was the best parts of my old job, without the politics, without the risk of elimination, without answering to a CEO who viewed legal as overhead instead of strategic asset. And the consulting fees, properly structured through my practice with appropriate margin, exceeded what I'd been making as general counsel. 6 months after I'd left, Rachel invited me to lunch. We met at a bistro near Titan's office, the kind of place where executives pretended to have casual conversations while conducting business. "I thought you'd want to know," she said after we'd ordered. "Marcus is struggling, can't find another CEO position. Word got out about the acquisition failure, the board governance issues. He's consulting, but not at the level he wants. Pride's taking a beating. How do you feel about that?" "Honestly, not great. He was brilliant at certain things, vision, fundraising, creating excitement around the company. Just terrible at execution, at valuing the people who made his vision actually work. The company's better off without him, but I don't take pleasure in his struggle." "That's generous of you." "Is it? Or is it just being human?" She paused. "The new CEO asked me to tell you something. She reviewed your separation agreement, saw the 14 months of severance. Wanted you to know she thinks you handled it exactly right. That executives who try to shortchange people on contractual obligations deserve to learn expensive lessons. Tell her I appreciate that. She also wanted me to ask if you'd be interested in more hours, maybe 30 per week instead of 20. We're growing again, and the fractional model is working well, but we could use more of your time." I thought about it. About whether I wanted to be more invested in Titan again, whether success there would be satisfying, or would just remind me of what Marcus had tried to take away, what I'd had to fight for instead of being given freely. "I'll think about it," I said. "Let me see how the current workload feels for another quarter." We finished lunch talking about cases I was working on, matters she was handling, the kind of professional conversation that lawyers and operators have when they respect each other's competence. When we said goodbye, she handed me an envelope. "What's this?" I asked. "Something I've been meaning to give you. Should have done it when you left, but Marcus wouldn't let me." Inside was a letter, handwritten on Titan letterhead. "Jordan, thank you for 8 years of exceptional service to Titan Industries. Your strategic counsel, regulatory expertise, and business judgment saved this company more than you were ever compensated for. I regret that we lost you. Regret that you had to fight for what you were contractually owed. Regret that leadership failed to recognize your value until it was gone. You deserved better. The company deserved you. I hope wherever you are now, you're being valued appropriately. With respect and appreciation, Rachel Kim." I folded the letter carefully, put it back in the envelope, felt something shift in my chest that I hadn't expected to feel. "Thank you," I said. "This means more than you know. You earned it. And Jordan, for what it's worth, I'm glad you fought for the severance. I'm glad you didn't just accept what Marcus offered. It forced him to learn a lesson he needed to learn, even if it cost him his position eventually. Some people only learn from consequences." I walked back to my office thinking about consequences and lessons, and the difference between revenge and justice. I hadn't been trying to hurt Marcus, hadn't been motivated by spite or anger. I'd just enforced what was contractually agreed to, used the protections I'd built in 8 years earlier when I'd understood that employment was always temporary and expertise was always at risk of being viewed as expendable. But the consequences had rippled outward anyway. The severance that exceeded his board representations, the due diligence that found the discrepancies, the acquisition that fell apart when buyers questioned whether other disclosures were similarly unreliable, the CEO position he'd lost not because I'd targeted him, but because he'd made promises he couldn't keep and representations that didn't match reality. Sometimes you don't have to burn bridges. Sometimes you just have to enforce contracts and let the consequences find their own way home. A year after leaving Titan, my consulting practice had grown to 12 clients and 5 partners. We'd built a reputation for sophisticated legal expertise delivered efficiently, for understanding business needs instead of just preventing liability, for being strategic advisors instead of just legal departments that said no to everything. I saw Marcus once more, at an industry conference 18 months after he'd tried to shortchange me on Severance. He was on a panel about corporate governance and executive leadership, talking about lessons learned from mistakes, about the importance of valuing expertise, about how the details matter in contracts and relationships, and whether you can actually trust the people you're supposed to be leading. The irony was thick enough to spread on toast. During the Q&A, someone asked about talent retention and what companies should do to keep their best people. You have to actually value them, Marcus said, and his voice had lost some of that CEO Polish, had gained something more human and possibly more genuine. Not just say you value them, actually demonstrate it through compensation, through respect, through honoring your commitments. I learned that the hard way when I lost someone whose expertise I didn't fully appreciate until it was gone. He didn't name me, didn't need to. Anyone who knew the Titan story knew what he was referring to. After the panel, he saw me in the hallway, stopped, looked like he was debating whether to approach, then decided to follow through. "Jordan," he said. "Marcus, I saw your consulting practice is doing well. Read about it in the trade publications. It is, very well actually. I should have kept you, at Titan. Should have honored what we agreed to instead of trying to minimize it. I know that now. I appreciate you saying that. Do you? Or are you just being professional?" I thought about that, about whether his acknowledgement mattered, whether it changed anything, whether I cared about his regrets or just about building something successful from the lesson his betrayal had taught me. "I appreciate it," I said honestly. "Not because I need your validation. I know what I contributed, know what I'm worth now, but because it suggests you learned something from the experience. That matters even if it's late." He nodded, and something in his expression shifted. "The severance you fought for, the contract enforcement. You were right, I was wrong, and I paid for being wrong in ways that went beyond just the money." "You paid for making promises to your board that didn't match reality," I said. "For treating expertise as overhead instead of strategic asset. For thinking you could optimize away institutional knowledge without consequences." I did. He looked at me for a long moment. "If you could go back, would you have just accepted what I offered, made it easier?" "No," I said without hesitation. "Because accepting would have taught you the wrong lesson, would have reinforced that you could treat people as expendable, could ignore contracts when they were inconvenient, could undervalue expertise without consequence. You needed to learn that the details matter, that contracts are protections, not formalities, that the people who build things know their value even when leadership forgets." He smiled, and it looked tired but genuine. "Expensive lesson. The best ones usually are." We shook hands and went separate ways. I don't know what happened to him after that. I hope he found something good, something that valued whatever he was good at, without putting him in positions where his weaknesses could damage people who trusted him. But mostly I stopped thinking about Marcus Holloway and started thinking about the life I was building, the practice I'd grown, the clients who valued sophistication and expertise, and the kind of strategic legal counsel that enabled business instead of just protecting against liability. The devil is in the details, but sometimes the angels are there too, waiting in contract clauses and automatic renewal provisions and carefully drafted severance terms that executives approve without reading carefully, because they can't imagine ever needing those protections themselves. Marcus dropped his severance bombshell thinking I'd just accept it, thinking legal expertise was overhead to be eliminated, thinking contracts were formalities that didn't really matter when it was inconvenient to honor them. Legal had other plans, and 14 months of severance, plus a thriving consulting practice built on the expertise he'd tried to minimize, was a pretty good outcome for reading the fine print carefully and being willing to enforce what was actually agreed to. The city looks different now from my office. Smaller building, better view, different perspective. I can see the harbor from here, see the bridges connecting different parts of the city. See the possibility that comes from building something you control instead of working for someone who views you as an expense to be optimized. Sometimes clients ask me about employment contracts, about what protections they should negotiate, about whether severance clauses really matter. I always tell them the same thing: read everything carefully, build in protections against future betrayals, and remember that the executive trying to eliminate you probably won't read as carefully as you should. The details matter. Sometimes they're the only thing that does.